Welcome to an AIC Insights video from the Northeast Ohio Ag Innovation Center. I'm Peggy Kirk, a member of the Innovation Center and director of OSU's Agricultural and Resource Law program. I'll be speaking with you today about adding agritourism to your farm and the importance of knowing Ohio's agritourism law. What I'll cover are the 4 different parts of Ohio's agritourism law and how to use those provisions for your agritourism activities that you're considering adding to your farm. We'll cover the definition of agritourism, zoning provisions in the law, as well as property tax and premises liability parts of the agritourism law. So let's begin by stepping back about 10 years ago to the passage of Ohio's agritourism law. That law established many different provisions intended to help grow our agritourism industry in Ohio and to address the needs of those operators who wanted to open their farms to agritourism activities. The first part of that law that's incredibly important is that definition of agritourism. What do I mean by agritourism? Well, there is a legal definition within the law, and you can see it here that agritourism is an agriculturally related, educational, entertainment, historical, cultural, or recreational activity. And that includes U-Pick operations and farm markets. And those activities are conducted on a farm that allows or invites members of the general public to observe, participate in, or enjoy that activity. Throughout this presentation, I'll give you the Ohio Revised Code sections that relate to the different parts of the law that I'm speaking on. And you can see here that the definition is in the Ohio Revised Code in 901.80. But what is, I think, challenging about this law is that there are definitions within that definition, terms that we also need to define and understand in order to know whether an activity meets the definition of agritourism. And the first one is farm. Note that the activity must take place on a farm. What's a farm? Well, the law defines that. And it says that a farm is land that is composed of tracts, lots, or parcels that are either not less than 10 acres and devoted to agricultural production, so they meet that 10-acre requirement devoted to agricultural production, or if less than 10 acres, then that devotion to agricultural production produces at least $2,500 annually from those agricultural production activities. Now, note I've underlined agricultural production, and that's because we also have a definition for that term. And under the law, agricultural production really means commercial production. So we're looking at land that is used for commercial agricultural production, and that landowner or tenant is engaged in commerce, in the business of commerce, of growing and selling those agricultural products that are raised on that land. And you can see a number of references to the types of agriculture that we're referring to here, whether it's aquaculture, algaculture, apiculture, animal husbandry, poultry husbandry, timber production, field crop production, and then a number of other specialty type crops like tobacco, fruits, vegetables, nursery stock, shrubs, trees, flowers, and sod. But also, there can be non-commercial activities on that land if that is timber production, timber growth for a non-commercial purpose that is on land near that adjacent to, contiguous to, part of that parcel that is engaged in agricultural production also comes in as agricultural production, and any combination of the above in that definition, whether it's, growing, taking care of, producing. And then agricultural production also includes the processing, drying, storage, and marketing of agricultural production, of agricultural products if those are conducted in conjunction with the production of the product. Now, if any of this sounds familiar to you, it's because it's the same definition that we use for current agricultural use valuation, or the CAUV program, that allows agricultural land that's engaged in agricultural production to qualify for CAUV differential property tax assessment. Very same definition. So if your land qualifies for CAUV, then it meets this definition of agricultural production for purposes of the agritourism law. But what is problematic about that definition that I began with for agritourism is it doesn't define what it means by agriculturally related. It says an agriculturally related activity, as you see here, but what does that mean, agriculturally related? What type of relationship are we looking for between that land and that activity? Well, there is not clear direction on that. And so it's going to be up to that interpreter of that law, for whatever purpose it's being interpreted, to decide whether that educational, entertainment, historical, cultural, or recreational activity is agriculturally related. A little bit of a problem area that we see in the law. So why does all this matter? The definition is highly important, as I said, because the agritourism law and the provisions that I'm going to explain to you apply only if those activities do meet that definition of agritourism. If we're doing something that doesn't fit within the agritourism definition, then these provisions do not apply to that activity. So, first tip on how to use the law is to make sure that what you want to do, that activity you're considering adding to your farm, does meet that definition of agritourism by being on a farm that's over 10 acres engaged in commercial production, or if under, then has that $2,500 annual gross income. You need to be doing an educational, entertainment, historical, cultural, or recreational activity on that farm. You allow or invite members of the general public to observe or engage in that activity. Remember, that activity has to be related to agriculture or agriculturally related. So moving on then to the second part of the agritourism law, let's discuss the zoning provisions in the law, which create an agritourism exemption from local zoning authority. And the law states, as you see here, that counties and townships do not have any zoning power to prohibit the use of land for a farm market or for agritourism. And it doesn't matter what the zoning district is designated as, if it's designated residential, commercial, agricultural, that does not matter. There is no zoning authority in that county or township to prohibit agritourism there. That doesn't apply to land within what we consider to be subdivisions from the law, and it also doesn't apply to cities or municipalities, villages. This is only out in our unincorporated areas where that lack of zoning power will exist when we're referring to agritourism activities. There are some other exceptions from the zoning exemption itself. And what those exceptions do is allow the county or township, if it's necessary to protect public health and safety, to regulate certain factors. They can regulate the size of a structure that would be used primarily for agritourism, the size of parking areas that might be necessary or required for agritourism, as well as setback building lines for those structures, and egress or ingress onto the property. Those are allowed to be regulated under the agritourism law, but again, they must be necessary, have a valid reason for protecting public health and safety. And even if there are regulations within a township or county zoning ordinance or resolution, those regulations cannot require parking areas to be improved, such as requiring a paved parking area or certain drainage on that parking area. And they can't prohibit the use of land or the construction of structures that are going to be used primarily for venting and selling wine that are located on land where grapes are grown. So some exceptions from the exceptions taking place here. So note that this agritourism zoning exemption only affects zoning. I find often that people are confused and think that it exempts from any type of regulation of that land use, and that is not the case. Agritourism activities can't be prohibited by zoning, and can have only a few types of zoning regulations related to zoning and the use of the land from the zoning perspective, but agritourism operations can still be subject to other laws that we might think of as land use laws. And those include the Ohio Building Code, the Ohio Fire Code, water and septic permitting laws, food licensing laws, alcohol permit laws. Those provisions still apply. So don't make the mistake of thinking just because you're exempt from zoning that you also will be exempt from any type of local government regulation, because that is not the case when we're referring to agritourism activities. And these other laws might also apply to your activities. So, how to use this part of the Ohio agritourism law? Well, first, it's important to know what your local zoning says. What does the provision in your zoning resolution say about agritourism? Many don't say anything, meaning that state law is the law that they're going by, that there's no ability to prohibit agritourism. But some might have some language in the zoning resolution that does address those allowable cases where zoning can exist, like setback lines or parking areas. So you need to look at your zoning resolution and see if it does have any of those exceptions from the exemption that might apply to your activity. Best way to do that, talk with your local zoning inspector. Confirm that they do think that you're agritourism, that the activity that you want to do is agritourism, and confirm whether there are any agritourism provisions within your particular zoning resolution. And then you'll need a little bit of help understanding whether those other types of provisions might apply, such as the building code, the fire code, those other types of laws that can affect your agritourism activities. Okay, so going on to number 3, the third provision in the Ohio agritourism law pertains to property taxes. And I mentioned CAUV earlier, that differential tax assessment that we receive in agriculture if our land qualifies under the CAUV provision for commercial production of agricultural products. This law in the Ohio agritourism law states that engaging in agritourism on that land that qualifies for CAUV does not make that land ineligible for CAUV, and there will be no penalty for converting land that might be engaged in agricultural production, perhaps growing crops on that land. If you convert that and use that for agritourism activities, this law says that that conversion does not disqualify that piece of the land from the CAUV taxation and differential assessment. So as far as that part of the agritourism law, how can you use that? Well, you do need to report on your annual CAUV application those acres that are used for agritourism. And county auditors have added that provision to the CAUV forms, and you'll see highlighted in yellow here. There's the other use, such as agritourism, how many acres are dedicated to that. But be prepared that the county auditor might question that land use change and confirm that that activity is indeed agritourism. If the auditor thinks it is not, then you might have to deal with that possibility of recoupment penalty notice, and you need to respond quickly and show that those activities do meet the definition of agritourism. And then finally, the premises liability provision of the law. This is the big one that many people are thinking of when they think of the agritourism law, and that's because it gives immunity to agritourism providers for certain types of harms that visitors to that agritourism activity might suffer. And the reason for this law is because some of these activities tend to be a little bit risky in nature. Being on a farm is a little bit risky in nature. But if people voluntarily choose to come onto that farm and engage in pumpkin picking or wagon rides or whatever that activity is, then the law says we're going to let them assume that risk from those inherent types of risks on a farm, inherent risks that are part of that agritourism activity. And we're going to give immunity to that agritourism provider if that injury arises during the course of engaging in that somewhat risky activity. So how does that play out? Well, we need to understand what risky activities are, or those risks that the law thinks are inherent to engaging in agritourism. And you can see here a list of 7 different types of activities. This is not an exclusive list. It's just saying we're including this within the definition of inherent risks. And these are dangers that are just part of that activity that you can't remove, you can't do away with. So those include surface and subsurface conditions of the land, the behavior of wild animals or domestic animals on that land, the dangers associated with our structures and our equipment that we use in farming and ranching activities, and also the possibility of contracting an illness from our livestock and physical contact with those animals or with animal waste. And then finally, the possibility that the participant themselves might behave negligently by failing to follow any instructions or using that a reasonable amount of caution that someone should use in that particular situation. So the law intends to remove liability from the agritourism provider if the harm arises from this type of danger or condition, or these different types of dangers or conditions. Now, there are some exceptions to that immunity provision, and the very first and most important one is that the agritourism provider must post and maintain the agritourism sign, and I'll show you that sign in a moment. If you don't have signs posted, the exact signs that are required by the law, then you can lose that protection that the law gives you from liability. The second is if you had actual knowledge of an existing dangerous condition and you just didn't warn that participant or that visitor, that client, that customer of that condition. You knew it was there, you just did nothing to warn them. And then third, you intentionally caused the harm or acted willfully with disregard to that customer's safety. Those are going to be exceptions. And so probably the most difficult situation is your signs and forgetting or failing or not knowing when your signs are not properly posted. So the sign is required by the law. It clearly states an agritourism provider shall post and maintain the signs that create or that contain a warning notice. And that sign has to be clearly visible to those property visitors, either at the entrance to the activity or at each activity. The entrance to the entire farm could work, or at the site of each activity. And it has to contain the specific lettering that is required by the law, so minimum of 1 inch in height in black letters and the specific language. And this is what the language looks like. You'll see here on the right side of the screen, there is specific language, and that language is providing a warning to those who visit the farm and saying, we just want to let you know that your operator has no liability if you're injured or if there is a death resulting from these inherent risks that come with engaging in this agritourism activity on a farm. And then it does speak to those examples of inherent risks that I reviewed with you. So this sign must be posted at the entrance to the farm or at each agritourism activity. And I recommend that you document your postings and you maintain those signs. If they fade, if they become tattered, maintain those signs and replace them as necessary. You can obtain a sign from the Ohio Farm Bureau or from our direct marketing program down at OSU South Centers. We have the language where you can print your own sign, and that template is available to you at no cost. Secondly, when it comes to premises liability, another way to use this law is to make sure that you do maintain those dangerous conditions that are not covered by this immunity provision. So they're not an inherent risk of engaging in agritourism, but there are other kinds of dangerous conditions on your property, such as the picture that you see here. It's nice if you can simply remove that dangerous condition, if that's possible. But if it's not possible, provide a warning, provide a barrier, keep people away from that dangerous condition in order to maintain the protection of the law. Also, make sure you're practicing good management practices. Don't rely on this law completely protecting you and you have no duty to protect or keep those people safe who come onto the property. You still need to adopt those best management practices that are recommended, the industry standards that are recommended for managing that activity, and certainly important to train all of your employees in those good management practices. And then finally, don't rely on this law as insurance. It's not insurance. You still need insurance coverage, and you need to tailor that insurance to those activities that you're having people engaging in on your land. And you need to update and regularly report those new activities to ensure that they are covered under your agritourism liability provisions. So that covers the law. I hope you found that helpful. You can find more information about agritourism as well as other laws that affect agriculture on our farmoffice.osu.edu site. We have an entire library there for agricultural and resource law that should help you. And we also have helpful resources through the Northeast Ohio Agricultural Innovation Center.